Welcome to this podcast. I'm Katie Broadfield, an Associate Director at Whitehead Monckton.
And I'm Joshua Parton, a solicitor in the Tax and Estate Planning team. And today we will be discussing the importance of making a will. So Katie, for those who may not be aware of the purpose of a will, what is it?
Thanks, Josh. A will is a written document in which somebody explains how they want their assets to be disposed of when they die.
And who should think about making a will?
Well, anyone over the age of 18 should think about making a will. They do have to have mental capacity of understanding what it is when making a will. If they've got any assets, such as money in a bank account or a house, then that's a really good opportunity to make a will to make sure that those assets will pass to people you've chosen when you die. Also, if you have any children under the age of 18, it's essential to make a will because you can appoint guardians to look after them. It's also particularly important for unmarried couples because they have far fewer rights than married ones in the event that one of them dies without having made a will. And when should you think about making a will, Josh?
Well, if you've not already done so, there is no time like the present. And even if you have made a will, it is always a good idea to review things regularly. We suggest every sort of 3 to 5 years to make sure that it reflects your current circumstances.
And what would happen if you died without having made a will?
So when you die, your money and assets would have to be divided up according to a rigid set of rules called the intestacy rules. Your assets may go to people who you would not want to receive them. So to give one example, when a married person dies leaving a surviving spouse and children, it is by no means certain that all his or her assets will go to that surviving wife or husband. The intestacy rules also require that distant relatives be traced if no close relatives survive. Making a will means that your assets can be divided up as you want them to be, but not how the law has decided they should be under the intestacy rules. So what sort of things do you have to think about, Katie, when you're making a will?
Some of the decisions you have to make are who you're going to appoint as your executors. These are the people who will be responsible for sorting out the legal and financial side of everything after you die. If you have children under the age of 18, you also need to think about who the guardians will be. If both parents have died, you need to appoint someone to look after your children. Also, you can think about giving specific gifts of money, and if so, how much you would want to leave, and at what stage you would want the beneficiaries to inherit it. You may also want to make specific gifts of land or property, or any specific assets that you may own. You then need to think about the residuary estate, the rest of your estate. Once all specific gifts have been made, who would you want to inherit the rest of your estate? You may also want to think about incorporating trusts in your will. Your legal advisor may advise that the creation of a trust could help to reduce inheritance tax or provide protection for vulnerable or young beneficiaries. You can also leave instructions in your will regarding cremation or other funeral wishes, organ donation, and also making arrangements for pets. How do you go about making a will, Josh? Are there certain formalities that need to be followed?
So a will has got to be in writing and signed by the person making the will in the presence of 2 witnesses who must also sign their name and give their details. This is so that they can be contacted if there is any dispute about whether the will is valid at a later date. The witnesses cannot be any of the named beneficiaries and they should not be married to any of them. It is also fundamental that the person making the will has mental capacity to do so. The test for capacity in respect of making a will includes assessing whether a person is fully aware of all their assets, knows who ought to benefit from their will, and understands the purpose of the will and its effect. The validity of a will can be challenged if the formalities are not followed, so it is important to ensure that a will is prepared properly, and this is where professional advice carries significant value.
If you would like to discuss putting a will in place or would like further information, then please give us a call, visit our website or contact us through our social media channels.